We're
This
now going to go
conference
ahead.
will now be recorded.
Okay, so let me start over again on that. The Lanterman Act is the Welfare and Institutions Code. It's a state of California's law that sets up the developmental services system, including the 21 regional centers that provide services. Uh, um, Please make sure you're muted, or I will mute you if you're not. Um, and then there is regulation, which we'll talk about at some length. And there are two sets of regulations that pertain to us. There's the Title 17 of the California Code of Regulations, and then there's also Title 22 of the California Code of Regulations. And finally, we have the home and community-based waiver system. So with that, we'll get started first with the Lanterman Act. Um, Okay, the Lanterman Act was named after a gentleman by the name of Frank Lanterman. Frank Lanterman was a member of the California legislature back during the 1970s. And Frank Lanterman had a very strong, he was a fiscally conservative Republican, but he had a really soft spot for people with disabilities. He felt that they were really the needy individuals who should be receiving services. And so if you go back and you look, um, he was responsible for much of the legislation that brought about the community-based services and the movement away from the big state hospitals towards community services. So on the intellectual and developmental disability side, we have the Lanterman Act. On the mental health side, so if any of you are working with Kern Behavioral Health, they have the Lanterman Petrie Short Act. The Petrie and Short were two other legislators that were involved with the laws. And just this most recent legislative session, the one that just ended, they made some modifications to the mental health law, the LPS law, as they call them. Those have stood the time, as has the DD system. So it is in the Welfare and Institutions Code. And if any of you want to find this, all the laws, if you go to dds.ca.gov, the DDS website, one of the first things you'll see is laws and regulations. And if you click on that, it'll give you two options. It'll give you one will be the Welfare and Institutions Code, the Lanterman Act, and the other one it'll give you is Title 17, which is the regulations specific to DDS and regional centers. But if you go to section 4501, which is basically sort of the preamble of developmental services in California. It reads, the state of California accepts a responsibility for persons with developmental disabilities and an obligation to them which it must discharge, affecting hundreds of thousands of children and adults directly and having an important impact on the lives of their families, neighbors, and whole communities. Developmental disabilities present social, medical, economic, and legal problems of extreme importance, or present, excuse me. The complexity of providing services and supports to persons with developmental disabilities requires the coordination of services of many state departments and community agencies to ensure that no gaps occur in communication or provision of services. So that's pretty important language there. It says that they're talking about uh, dealing with social issues, medical issues, economic issues, legal problems. Um, so a number of issues, the state of California is saying, hey, we have a responsibility for people with developmental disabilities to provide them with services. The Welfare and Institutions Code further states under 4501, a consumer of services and supports, or where appropriate, his or her parents, legal guardian, or conservator shall have a leadership role in services designed An array of services and support should be established which is sufficient, complete to meet the needs and choices of each person with a developmental disability, regardless of age, degree of disability, at each stage of their life, and to support their integration into the mainstream life of the community. To maximize the extent feasible, services and support should be available throughout the state to prevent dislocation of persons with developmental disability from their home community. So the state again is saying, hey, we're taking on this responsibility to give people a full array of services and choices about how they want those services. And this is throughout the lifespan. So, services for the developmentally disabled from 0 to 3 fall under a different program. It's called Early Start. It's a federally funded program. But for 3 years old through the continuation of life until someone passes on, the state of California is saying if you have a developmental disability, we have a responsibility to provide you with services and supports. And to the extent possible, they should be available throughout the state. Uh, we all know the reality of these days with the rates that we get and with the employment crisis that's occurring, that there are times that it's hard to find all the services that people need and to be able to get them the services that would be appropriate for them. But the state is taking on that responsibility. Furthermore, the Welfare Institutions Code says services and support should be available to enable persons with developmental disabilities to approximate the pattern of everyday living available to persons without disabilities of the same age. Same things that we do for ourselves, we should do for our clients. Consumers of services and supports, and where appropriate, their parents, legal guardians, or conservators should be empowered to make choices in all life areas. These includes promoting opportunities for individuals with developmental disabilities to be integrated into the mainstream of life in their home communities, including supported living or other appropriate living arrangements. In providing these services, consumers and their families, when appropriate, should participate in decisions affecting their own lives, including but not limited to where and with whom they live, their relationships with people in their community, and the ways in which they spend their time, including education, employment, leisure, and pursuit, and planning and implementation. Now, that last paragraph basically reads almost like home and community-based waiver, what the feds are saying. So California and the federal government are in line in terms of it's about choice. And it's about giving people options about where they live, what they do, how they should be integrated into the community. So the Lanterman Act was very forward thinking. It was originally placed into law in 1977, and there have been modifications made to it over the years. There was a piece of legislation in this year's legislative session which ended up not making it through, but would have made some very major changes to the system. But over the next couple of years, we may see that come back again, and so we will have to wait and see. Now, Valerie, what was it that you wanted to share?
Oh, Dante was just asking for the slides, if it's possible.
Oh yeah, the slides will be placed on our website along with the presentation as well. So, and that will probably be later today or to no later than tomorrow. So, but this language here, I just cut and paste right out of Lanterman. So I'd love to say that I wrote all this and I'm really brilliant and forward thinking, but no, this was people in the legislature, and I'm just and I want to make sure they get the credit where credit's due. Okay, and then finally, the one last thing I've got under 4501, and the Lanterman Act goes actually from the 4400s all the way up to the 4700s. So there's a number of sections, and there's an index in the beginning of it that you can look at. And if you go online and you get the DDS version, that is out there. One of the things that it has is it has a search function. So if you type in a keyword, so for example, if you are providing services for adults in a day activity program, and you want to know about day support, you can type in like day services, and it'll pop up with a number of potential places in the act, and then you can go through and sort and figure out where it is, because it's a long act. It's about 300 and some odd pages, so it's hard to, unless you don't sleep at night and want to read through it. It's, I don't suggest knowing. I mean, people sometimes say that, Jeff, you know this stuff pretty well, but that's from 45 years experience, and and even I need to go back and look up sections all the time if I need to find something. I sort of know offhand kind of where it is, but then to find it. The contributions made by parents and family members in supporting a child and relatives with developmental disabilities are important to those relationships and should be respected, fostered, and maximized to the extent so that consumers and their families can build circles of supports within the community. So again, and it goes for adults as well, when we're looking at developing our services, to the extent that the individual, and throughout the Lanterman Act, they've switched to the term consumer. So when they refer to the people we serve, they call them consumers. It's controversial about what people should be called. Our local group has, many have said, we're clients. We don't mind the term client, but the client has sort of become passe for the most part. Groups have gone to the term consumer. Now some people are saying just call people individuals, because that's what we are. We're all individuals, and that's what we should be referred to. So I will use them interchangeably because we all use some of all of them. But the Lanterman Act specifically uses the term client. Okay, in 1982, which probably was before some of you were even around, the state of California had one of its many recessions that the state goes through from time to time. And in the 82-83 year, what the Department of Developmental Services did, because of budget cuts that they received from the state of California, from the governor, from the legislature, is they went to what was called a basic habilitation plan. So for those of you who like alphabet soup, a BHP, and what that did was it said when you're writing an IPP, you write down a place for someone to live, a place for someone to go to during the day, be it school, be it an adult day program, be it work, and you write down objectives related to someone's health. 3 items. Okay. Once you write down those 3, then you take a marker or a pen or whatever, and you write a line across the IPP. And anything that goes below that is subject to availability of funds. So if we have funds available, then we will fund that. If we don't, we won't. Excuse me 1 minute. I've got some people doing construction here, and I think they just set my dogs off. So give me 1 second to do that. Be right back.
And also just a quick reminder, I do have about 4 callers that are unidentified. So I really want you to get these CEU credits if you're needing them. So if you could find a way to identify yourself, even if you want to unmute for a second and just maybe let us know that you're here. If there's not a way that you can get into the chat, I would greatly appreciate that. I think I have everyone on there. I just have 4 callers that I'm not entirely sure who is on the line.
Yeah, we want to make sure you get the credit. So anyways,
Can you hear me?
Yeah.
Cynthia Guerra with the Moore facility.
We got
I
you.
can't get in. Oh, you got me? Okay, thank you. Okay.
Um, so anyways, what ended up happening is the state said, we'll fund the first three. So if somebody has an issue with a place they need to live, like residential care, if they need a place to go during the day, like a program, or if there's some health issue that's not covered under a generic resource like Medi-Cal or insurance, we'll pay for that. Anything below that line is based on how much money we got left over. And they call that a basic habilitation plan. Well, the at that time it was we still used the R word, and so the Association of Retarded Citizens, the ARC of um, San Diego, and I left it in there because that's the way if you go and look up the case law, that's how it reads. Association for Art versus Department of Developmental Services. There was a lawsuit saying, you can't do basic habilitation services. That's not what I just read a minute ago from the Lanterman Act, where it talks about the whole array of services over the person's lifetime. That you're restricting those services to just those three, and that's not right. And the case went all the way to the California Supreme Court. And I remember very well when the decision came out. And basically, what it says, the legislature has fashioned a system in which both state agencies and private entities have a function. Okay, so the first thing the legislature says, okay, it's a system where DDS does some of it, and regional centers, which are a private company, does some of it. Okay, so that's DDS, a state agency, has jurisdiction over the execution of the laws related to care, custody, and treatment of the developmentally disabled person, while the regional centers operate by private nonprofit community agencies under contract with DDS are charged with providing developmental disability persons with access to facilities and services best suited for their needs throughout their lifetime. Okay, so the court further stated in the Lanterman Act, the state of California accepts responsibility for the developmentally disabled citizens and an obligation to them which it must discharge. Again, 4501, the section I just showed you a few minutes ago. The legislature has not only recognized that persons with developmental disabilities have the same legal rights and responsibilities as those guaranteed to all other individuals by the federal Constitution and laws, the Constitution and laws of the state of California, but has also granted them certain statutory rights, including the right to treatment and rehabilitation services at the state's expense. Okay, so what ended up happening then with this is the state Supreme Court said no. Our friends in the legislature, we have three different bodies of government. We have the governor, we have the legislature, we have the courts. Courts said our friends in the legislature wrote the law in such a way that people have an entitlement to service, and that to write a plan that says we'll only fund for these three things and then anything below that is based on availability of funds is not consistent with the Lanterman Act as it was written under section 4501. So what this means is that we have an entitlement in California. So when we talk about anyone is able to get services, much of that entitlement came from this lawsuit that was filed by the San Diego ARC that went to the Supreme Court, and the Supreme Court said that. But one of the interesting things about that lawsuit is that the Supreme Court said that it was the intent of the legislature that this be an entitlement. So that means that if we had a really bad fiscal year, our friends up in Sacramento could unintend or reintend, or I don't know what term you would use, but they could come back and say, okay, we no longer believe that this should be an entitlement anymore. California can't afford to have an entitlement to services anymore, and therefore we're gonna not continue Section 4501. We're going to rewrite that and do something else. So the legislature could do that. They haven't. It would be a political time bomb because the people are so committed to the services that we have. It would be a major shift, and I don't think it's going to happen in our lifetime. But if when I used to work at the regional center, sometimes I would have families call me and say, "Hey, listen, we're looking at moving, and we're going to be moving to Nevada, and we want to move to Nevada because we're going to retire, and there's no state income tax in Nevada, and so we'll save money, and it'll be good for our family." And I said, "So, and what are you going to do about your son who's going to day programming?" "Well, we'll just get him signed up for day programming in Nevada." And I said, "Okay, so you sign him up for day programming in Nevada, and 5 years from now, when his name comes up on the waiting list, you can get him services." And they said, "What do you mean? He's a client, the regional center, that doesn't he get services?" Well, no, California is the only state that has an entitlement to services. In other states, the state goes to the federal government and they contract for a certain number of Medicaid waiver slots for the home and community-based waiver. They say, okay, so I'm just picking on Nevada. I don't know the numbers, and I don't. It's a nice state. I don't want to pick on them, but anyways, let's say they say we want 20,000 people on our waiver. Okay, so if you're 20,001, you're not going to get services because they're only contracted for so many. And what ends up happening on waiver is 50 cents on a dollar is state money and 50 cents on a dollar is federal money. So they say, okay, we're going to budget for 20,000 people of Nevada money and 20,000 people of federal money. In California, we've done it differently. Right now we have, I believe, close to about 300,000 people on the waiver, but there's 425,000 in the system. So there are 125,000 people in the system that are getting all of the funding that they get is state dollars. So we've made a commitment to provide services to everybody, whether they're on the waiver or not. So that's the entitlement. Nationwide, there are 75,000 people. Is that right? I think I haven't seen the number lately that are waiting for services. With Florida and Texas being the two largest number of states with waiting lists, but there are waiting lists in a large number. I think that number maybe 35,000 may be too low. But anyway, so California says anybody who walks into the front door of the regional center, goes through the assessment process, is found eligible for services, gets the full array of services through the planning process once their eligibility is completed, and based off of their IPP, that's the service model, and that comes about, like I said, both because of what Lanterman says under 4501, and also because of this lawsuit that was filed by San Diego ARC. So if any of you are interested in the history of the regional center system, that's a good thing to look up, is that particular lawsuit. Okay, some of you have probably heard the term Olmstead. Okay, Olmstead was a case that came out of Georgia, and it had to do with some individuals who had a developmental disability who were being housed in a nursing facility. And they said, we don't want to live in a nursing facility. We don't need nursing care level of care. And the state said, this is what we have available. This is what we budgeted for. This is cost effective for us. This is where we want you to live. So they took their case to the U.S. Supreme Court. So not California Supreme Court, national case. And on June 22nd, 1999, the United States Supreme Court held in Olmsted versus LC that unjustified segregation of persons with disabilities constitutes discrimination in violation of Title II or of the Americans with Disabilities Act. So you can't segregate somebody, put them in a facility or an institutional type setting when they don't want to be there. The court held that public entities must provide community-based services to persons with disability when such services are appropriate. The affected person do not oppose community-based treatment, and the community-based services can be reasonably accommodated, taking into account the resources available to the public entity and the need of others who receive disability services from the entity. So the court said basically, you got to provide the services in the community. Can't be segregated services anymore for individuals. California was pretty good about, even back in 1999, about providing community-based services. Other states were not. Some states had very limited community services. So Olmsted basically changed things at the federal level and made it so that we had to start looking at things a bit differently. The Supreme Court explained that its holding reflects two evidential judgments. So two things that the court found. One, institutional placements of persons who can handle and benefit from community setting perpetuates unwanted assumptions that persons so isolated are incapable or unworthy of participating in the community. So it said, hey, when we put people in institutions and leave them there, it devalues that person. They don't have a lot of worth, or at least they're not perceived as having a lot of worth. We as a society aren't giving them their just due. Secondly, confinement in an institution severely diminishes everyday life activities of the individual, including family relations, social contacts, work options, economic independence, education achievement, and cultural achievement, educational advancement and cultural achievement. So the court was very clear in that the preference for persons with developmental disabilities needs to be in the community. So a state can't look at it and say, okay, economically, it makes more sense for us to put people in institutions because we congregate a whole bunch of people together and we can cut our costs and do this and that rather than serving an individual here and serving an individual there. Can't do that. It has to be based off of the assumption that people have services in the community. Okay, now this is where we now come into Medicaid waiver, which was sort of an offshoot of Olmsted in some ways. So as we moved forward with developing plans, and every state has an Olmsted committee. California has a committee that meets regularly and discuss how it's doing in providing services. And Olmsted, although the case was, I think, two women who had developmental disabilities, it is not only developmental disabilities, it's physical disabilities, mental health, elderly, other groups of individuals who have historically been placed in long-term institutional care were all affected by the Olmsted decision. Okay, in 1981, so this is even predates Olmsted, as part the Social Security Act, part of the allows states flexibility in eligibility for home and community services to institutions and care. Section 1915 is originally intended by federal lawmakers to provide states with mechanisms to control Medicare spending without increasing costs to the federal government. And some of you have heard the story that I've shared about the young lady, Katie Beckett, who was in a nursing home. And when the parents decided they wanted to take her home, the feds said, we'll pay for her to be in a nursing home. We won't pay for her to be at home. And the family contacted, at that time, President Ronald Reagan. And that's how this section of the code, the 1915 waiver section, was created. And home and community-based services started in 1981. Today, Medicaid and in California, it's Medicaid in 49 states. In California, we got to be different, so we call it Medi-Cal. But it is jointly funded federal state health insurance programs for certain low income and needy people that include long-term care benefits. The HCBS waiver program recognizes that many individuals at risk of being placed in medical facilities can be cared for in their homes or communities, preserving their independence and ties to their family and friends at a cost no higher than institutional care. Over the last 40 years, the program has expanded in California, both in number of individuals on the waiver and the number of services that are included. Okay, so last year's budget, not the current year's budget. The DDS budget was $12.8 billion, of which 5.2 of it was federal money. So when I was talking about earlier about how the state of California budgets money for the system, both to get money from the federal government, but also from the state government. So a little less than half. So if you take 12.8, half of that would be 6.4, and the feds are coming up with 5.2. So a little less than half of the money that runs the California system is federal dollars. So it's a big part, a chunk, and that's why we have the Medicaid waiver final rules, is because the federal government says if you want that $5.2 billion, these are the rules that you have to follow in order to get that money. So California is moving in that direction. Okay, now we're going to move into a slightly different area. So that was background on how some of the laws got made, the Lanterman Act, the interpretation of the Lanterman Act by the California courts, the federal courts' interpretation of the rules, and also how Medicaid waiver got started. Now I want to talk a little bit about regulation. Now, when a law is passed, so our friends in Sacramento make a change to the law regarding developmental services. It then goes to DDS, and the DDS has to decide how that's going to be implemented. And how it gets implemented in California is it's a pretty involved process. So law gets passed. Okay, so how are we going to put this into action? How are we going to tell the regional centers they should do what they should do and how to make this trickle down to vendors and to families and to clients? Well, the first step is for the Department of Developmental Services to write up regulation. This is how we're going to make that law work. Okay. And that regulation goes to an entity in California called the Office of Administrative Law. The OAL is responsible for ensuring that California state agencies comply with the rulemaking process and standards set forth in the California Administration's Procedural Act. A regulation is any rule, regulation, order, or standard of general application, or the amendment, supplement, or revision of any rule, regulation, order, or standard adaptation by a state agency to implement, interpret, or make specific laws enforcing administration by it. When adopted, regulations, every department, division, office, your microphone. Okay. Let me see if I can figure out who it is. Oh, no, I didn't do it.
It's Aga Ignacio. They got disconnected and logged back in.
Okay, well, make sure that you turn off your mic. Oh, there we go. Okay, so what are we talking about here? So when your regional center service coordinator comes out to your facility and they have a checklist and it's got what they're looking for to do your evaluation. And it refers to a series of numbers that are and most likely in Title 17. So Title 17 is regulation. It's exactly this. So what happened was the Department of Developmental Services wrote up something. They went to the Office of Administrative Law. The Office of Administrative Law um, then reviewed the document that DDS put together and decides a couple things. One is, does it meet the requirement of the law that the legislature passed? And two, does it meet the state constitution in terms of rules and regulations that everyone has to do? So if you actually go online and go to Westlaw, which is a company that actually prints, well, now they do it digitally. I don't know if they actually physically print it, but they have all of the California code regulations. There are a number of them. We talk about 17 and 22, but guess what? There's 1, 2, 3, 4, 5, 6, and each one covers a different area of California law. So, and once a regulation is approved by the Office of Administrative Law, and there is a process. They look at it, they say, okay, this makes sense, so we can go with this. And then it goes to public hearing. People can give input. It then goes back to administrative law. And then finally, it becomes the actual regulation. So regulation goes through a process to get put into place. But once it's put into place, it has the same effect that law does. Once in a very great while, a regulation gets challenged because people say that it's not consistent with the law. For example, when supported living services first came out, the original law says it can't cost any more than if that person had gone into residential care. Well, some people challenged that, saying that's not consistent with 4501, and and they went to administrative hearings, and the regional centers were losing, and the state finally said, okay, well, we'll change that to make it more consistent with what's the person's service and support needs. So there is a whole process that's involved in making regulations. So when we talk about the rules that you as a provider have to meet, and now we're talking, okay, federal home and community-based waiver, the 10 final rules. Then we're talking the Lanterman Act. Then we're talking Title 17 from DDS. And then on top of that as well, if you are a licensed program, so you're providing adult day services under that are site-based, so you're a licensed day service, or you're a residential provider providing services under the community care licensing, you then fall under Title 22. Interesting enough, when the state of California back in the 1980s first decided that supported living services should be an option for folks. Also, subsequently, when they decided on family home agencies should be an option for folks. The Department of Social Services in both cases, the people who are community care licensing, said, well, we're not interested in this stuff. That's not what we do. We don't want it. So those got put into Title 17, even though they deal with living arrangements, they're in the DDS regulations. They're not in community care regulations, although some people think, well, it makes more sense for if it's a type of living arrangement, shouldn't it be followed by community care licensing? So if somebody wants to become a family home agency and finds homes for their folks, all that process goes through regional center and DDS. It doesn't go through community care licensing, even though it's a community facility for people. So there are different rules and regulations that get developed for different groups. Eh, and then, like I said, there is the California Code of Regulations. And I like this picture on the left here because it sort of reminds me about how big all the regulations are. If you probably look at it, it's probably about pretty accurate. Um, it's the official compilation and publication of the regulations adopted, amended, and repealed by state agencies, through the Administrative Procedures Act. So it goes through this whole process, and then and have been filed with the Secretary of State and have the force of law. So although the legislature didn't actually write the regulation, they wrote the law that made it so the agency could write the regulation, and then the regulation, once it goes through the Office of Administrative Hearing, goes through public hearings, goes back to the administrative offices, and gets certified by the Secretary of State, it becomes law. So what's in Title 17? So somebody says, "Oh, that's just regulation. We don't have to follow that. That's not Lanterman. I follow Lanterman. I don't necessarily follow what it says in the regulation. No, the regulation has the effect that a law has in California. Okay, the California Code of Regulations is the official. Okay, um, is updated fairly regularly. If you want to, the DDS website also has available Title 17 regulations. You have to go to community care licensing to get the Title 22 regulations, but they keep them current. So if, for example, our friends in the legislature change the law, they add something, a new type of residential option, let's say, when they developed over the last few years, when they developed some of the enhanced behavioral support homes or the star homes or some of the other types of residential facilities that they did, that all had to go through the process of getting put into regulation and then put into Title 17. So as there are updates to Title 17. Same thing for Lanterman too, as there's updates. Those are posted to the Developmental Services webpage. So the way I keep current, I mean, I do read a lot about laws and regulations and what's going on in the legislature, but to make sure if I'm going to look at a section of the code or regulation, I go to that section of the code or regulation and get the most recent version. And if you look at the bottom of any section in either law or regulation, it will give a date. And it'll also say if it's been amended or changed or anything else. So if it says, modified in July of 2021, then that's the most recent version of it. And so you can keep up to date with as changes are made. But if, for example, a regional center staff person comes out to your facility and has their checklist of Title 17 things and marks something off as that you're not in compliance with, and you're saying, what in the heck is that? I've never heard of that before, or I'm not sure what they mean by that. You can take the numbers of that section, go to the DDS website, go to where it says laws and regulations, click on Title 17 regulations, go to, and then once you get into it, type in that number that you're looking at, the particular section, and it will take you specifically to that section, and you can read it and get a better idea of what it is specifically that the regional center's talking about. Okay. Now, if you were to go into again, I always complain about the fact that we have all these different alphabet soups for everything. Everything's got an abbreviation. So CCR stands for California Code of Regulation. So when you're and so when you hear Title 17, Title 22, those are under the California Code of Regulations. So under Title 17 is public health. And there are a number of divisions in public health. So DDS is just one division of Title 17. If you go into Title 17, there's stuff on hospitals and vaccines and all kinds of other things. But if you go to Division 2, which if you, and again, on the DDS website, it takes you right to Division 2. There are 4 chapters that specifically address regional centers. Okay. The first chapter has to do with general provisions. Those are just like an overview of the system. The second chapter is early intervention. So unless any of you are doing services to 0 to 3-year-olds, that really doesn't pertain to you. Most of the language that relates to how you operate the program that you're doing can be found in chapter 3, community services. And then chapter 4, which had to do with case management, at some point the legislature or the Office of Administrative Hearings repealed that. So if you go into what is chapter 4, it'll say it doesn't exist anymore. So it's still on the books, but there's nothing in that chapter. So most of the stuff that we deal with is in chapter 3. Okay, and this is what you would find if you went into chapter 3 of the Title 17 regulations. General, which is talks about just it gives definitions. So how the regulations perceive something. Vendorization, how do you go about vendorizing? Regional center administrative practices, regional center budget deficit. Then when you see something that says repealed, like section 3.5, that's no longer in the law. Residential services and quality assurance. So when they come out and they're looking at your residential facility, what authority do they have to do that? Family home agencies, like I was talking about, that didn't go into community care licensing, it went into the DDS. Intermediate care facilities, standards for non-residential services, day programs, other types of things, rate setting, non-residential services, rate setting provisions. So there's a number of things. So how we get our funding, how we're evaluated, how regional centers operate are all in Title 17. And like I say, most of it is in that chapter 3. So, and it goes on. It goes all the way up to subchapter 24 of enhanced behavioral support. So there's information about transportation services, supported living, respite, a number of other things are all there. And if you happen to need to know or run across it or find yourself in a situation where you're being cited or warned or whatever about something and you want more information on it, this is where you go. And you would be able to find what the rules and regulations say on that particular topic. Okay, the next area of the California Code of Regulations is the community care licensing section. So any and all of you who are licensed as either an adult day type of program or a residential type program would fall under Title 22 as well. So again, if we go back to my first point, we've got the federal rules, then we've got the state law, then we've got state regulation. and you fall under state regulations. You fall under the regulations both of the Department of Developmental Services, and also in many cases you fall under the regulations of the Community Care Licensing Title 22 as well. The two main sources of authority for Community Care Licensing Division activities are the California Health and Safety Code and the California Code of Regulations. Now, as I mentioned earlier, the Lanterman Act falls under Welfare and Institutions Code. Again, there are a whole series of different laws depending on different. Licensing falls under Health and Safety Code of the law. So that the Health and Safety Code, when they make changes to that relate to community care licensing, those then ended up going into Title 22 through the administrative law process and then get put into the regulations, so that when the licensing evaluator, and in most cases it would be someone out of Fresno coming down to your facility to review your records, were to look at what's going on in your facility, they would be looking at the rules according to the Title 22 California Code of Regulations. So there are different sections of the code depending on what it is that's involved in the particular activity. If you go to the California Code of Regulations Title 22, Division 6 is where you'll find the material specific to community care licensing. And again, Title 22 is a very large set of regulations and covers a number of areas other than just community care licensing. It covers some intermediate care stuff. It covers hospitals. It covers a number of other areas. So we're only interested in, for the most part, in that area that relates to the work that we do. Division 6 is where you find the rules for community care licensing. Now, there are first and foremost a section of the regulations that are general licensing requirements. And these are numbered. So I think it starts off like 8001 and then goes from there. And then what you'll find is that when you then get into the, let's say for example, you're an adult day program, so you fall under Chapter 3. The numbering system will be 83001. So it will start with the same numbering system that you saw in the general licensing requirements, but if there's anything additional to the overriding rules that are specific to your type of facility, the numbering system will correspond, so that there'll just be that beginning number will be the chapter that you're in. So it'll be so that's how you know. So you can look at the general licensing requirements, what they're saying for that, and then you can go down into specifics. And this is a little different than what you saw in the DDS regulations, a slightly different way of doing things. But so anyway, so if you're a small family home, you would fall under Chapter 4. So if licensing comes out and cites you, probably a good idea to look at the general licensing requirements first, so see what number there that it is, and then find the corresponding number that has a 4 in it in the small family care section to find out if there's anything specific related to your type of license that's involved with that as well. So we know that we're working in conjunction with the licensing requirements. And we have, under this section, general licensing, social rehabilitation facilities, and sometimes those are related to substance abuse or other types of program. We have adult day programs, adult day support center, which I'm not sure what that is, frankly. Small family homes, group homes, adult residential facilities, community crisis homes, transitional housing, crisis nurseries, foster family home, um, residential care facilities for the elderly, residential care facilities for the chronically ill, foster family agencies, adoption agencies, foster family homes, temporary management of adult community care facilities and residential care facilities for the elderly, and then enhanced behavioral support homes. So those are all under the Title 22 regulations. Okay, now this slide's a little bit hard to follow, unfortunately. It's a photograph off of a presentation that I was um, involved with one day. So, but this is what California DDS vision and guiding principles are. Um, and basically, first and foremost, it's to uphold established rights. Okay, we as citizens all have rights, and our consumers, clients, individuals, also have established rights. And we want to make sure that in the work that we're doing, we're protecting people's rights to community, to services, to supports, to their finances, to their privacy, etc. Um, show dignity and respect. Okay, so we want to make sure that in the work that we do, we're treating people the way we would like to be treated. This morning, I was on a phone call where I was upset with some customer services that I was receiving, and I was getting a little bit testy. And I said to the person, "Hey, I'm not getting testy with you. I'm getting testy with your way of doing your company's way of doing business. So, just want you to know that I'm not in your face. I'm in your company's face." So I think we want to make sure that when we're doing things that we really are sharing with people, that we respect them and we honor their dignity. Um, we seek equity. We want services to be equal across the board. And this is a challenge. If for those of you who have been following it, and there's a really good document that was put out last year by a group called Voices United, and it talks about the inequities within the regional center system. And there are services and supports, unfortunately, vary widely by different regional centers. So some regional centers provide more services, some provide less. There's not an equity in the amount of services that the system provides, and also by ethnicity. So it really creates a challenge when people of color, especially, are receiving less services than Anglos. And I don't think that there is a prejudice out there among administrators. I think it has to do with systematically the way we developed our system initially and how we provide services and how we approach families. And for families who aren't necessarily English speaking, there can be a number of challenges. But just for an example, if you look at Hispanics clients at current regional center, on average, it's in the 40 to 50 cents on a dollar of what the region current is spending on adults who are Anglo. So why is there that difference? Is it because the families aren't asking for the same level of services? Is it because it's not being provided? Is it a cultural issue? I don't have the answers to that. There are people that are wiser and more involved that are looking at that right now. The state's spending quite a bit of money on trying to address the equity issue, and it's become a very big challenge. Also, dollar amounts. When right now, if you look at per capita spending, it varies all over the map in terms of what regional centers spend on clients on average. And it, according to that Disability United study, Kern is in the bottom five in terms of spending on its consumers. Um, so it again varies from regional center to regional center, and that's something that the DDS and the regional center system is looking at trying to address also. In that we really want to try to make sure that no matter where you are in the state, I mean, there are some geographic differences. I mean, the cost of living is so much higher in the Bay Area or in Southern California than it is here in the Central Valley. So there may be some regional equity differences, but overall, if you look at the numbers right now, that's not how it pans out. It's not that way at all. Okay, so we really, moving on, we want to apply person-centered practices to the work that we do so that when we're talking, the whole thing of what's important to someone and what's important for someone. So we want to make sure that when we're meeting with them, we're doing that. One of the big challenges that we have is just the system has never provided the resources in terms of case management and for vendors to take the time to do a good. If you go online and look at some of the examples of person-centered planning done by Michael Small, SMULL, and associates, and some other groups that are doing that were sort of instrumental in developing person-centered planning for developmental services. Those plans are not 45-minute meetings. And there's a great deal of time that goes into working with the client and developing information from the client and their circle prior to the meeting, during the meeting, and then the final document that comes out. Now, one of the things that the state is doing right now is in trying to deal with both the equity issue and with the issue of making sure that plans are person-centered, is they're looking at the possibility of making a standardized IPP statewide. Right now, there are 21 regional centers, 21 different ways of doing IPP. So a lot of them are using the SanDisk system has got a IPP document that you can create, and there's some others that have. There's a Caseman. There's another one that I think Orange County and a few other regional centers are using, but it's not standardized throughout the whole state of California. And so the state is looking at maybe making a standardized document, hoping that will help to make sure that the services and supports that people get are enable community inclusion across services. So we want to make sure that people are involved in their communities so that services are not at a site all day long, every day. We want people to be throughout the community. So, and that's also age appropriate. So what you would do in terms of services to integrate a youngster versus what you do to integrate an adult might be very different. But how do we go about doing that, and who's involved in developing those services and implementing that is becoming an important part of what we're all about as providers, because we're the ones who are really where the rubber meets the road and should be really actively trying to make sure that our clients are out there. Prioritize information, choice, and self-determination. Again, we've talked about this before, if you've been on any of my other classes, about how choice is an interesting concept in that for many of our individuals, they haven't had a very wide repertoire of exposure to things because historically they haven't had that much community activity. I one time took a young man for a potential placement to visit a facility over in Ventura, and this person had never been to the beach. Young adult, so that was not part of their repertoire. When we first started at Bakersfield ARC to do community services, and we said, okay, so if we go out in the community for the day, where would you like to go? And people oftentimes said Walmart, Valley Plaza, Dollar Tree, because those were the places that oftentimes would be that's where they went with their family or their care home. And getting them involved with, well, what if we try this activity and see if you like it or not? And in many cases, now clients are asking for things that 6 months ago, a year ago, they had not a clue. So when you're wanting to help people make choices, you want those choices to be informed choices, and so that people know what options are out there and what are available. And I'm still old-fashioned, and I still get the Bakersfield Californian every day, and I look at things and I see what's here in town and what's going on, and what plays are out there, what activities, what barbecues, charitable events. The Greek Orthodox Church is having something, and really look to see what sort of activities I would like to do in the community. Now, you don't have to necessarily. This is not a pitch for the paper, but you can find those online. You can social media is a good place to find activities, so you can find things to do for your individuals. Support the whole person. I still remember reading a plan one time where somebody was chatting about the individuals having some significant seizure problems. Susie had 15 seizures over the last quarter. But then a little later on in the document, under the health section, they put health is fine. Well, no, health isn't fine. This individual has got a significant problem that needs to be addressed for both their health and for their safety, because depending on how and where they have that seizure, that could be very dangerous for the person. So when we're looking at the person, we need to look at the whole person. We're not just looking at, okay, they come to our program for 6 hours a day, so let's just talk about the 6 hours a day that we do our program. There's a lot more involved with that person. What's going on with them emotionally, socially, health-wise. So we want to take a look at the whole person in terms of our thinking about what goes on. Because if somebody is unhappy with the roommate at their residential care facility and they're not getting along, what effect is that going to have on their day program? And what's going on with their participation, their socialization, their mood, how they treat the staff, how they, et cetera. So we want to look at the whole person. Okay, emphasize prevention and preventative practices. One of the things that I would really like to see is for our clients to get the same sort of health care that you and I do, and other sort of things that, we talk about. If you turn on the news or anything, like, for example, this is a breast cancer awareness month, and they talk about how women over a certain age should start getting regular mammograms to test, and self exams and other things that you can do, looking at your family history for the specific genetics that are related to it. And so we want to do that for our clients as well. So we want to make sure that they're getting wellness health care, so that women are getting the type of exams that are necessary based on their ages, to make sure to screen for potential challenges. Men are getting healthcare exams that are related to their needs at different ages, to again for their health. So and then we're not only are we looking at that, but we're also looking at mental health too. That we, to the extent that our clients are involved in the community, that are active, that are participating, they're going to be happier. And we need to really look at loneliness, isolation, anxiety, depression, as well as sometimes, our clients can have mental health challenges as well. And are we addressing those, and are really looking at trying to be preventative in terms of, so that we don't have a major uh, challenges for that individual in the behavioral health realm as well. So we have physical health, behavioral health, social health, a number of areas we want to be addressing. Um, we want to look at how we're funding programs. And to the extent that we can look at combining funding, so we can get some of it funded through Medi-Cal, or some of it funded through the Department of Rehab, or some of it funded through regionals. Again, look to the different resources that are out there, and not only just depend on KRC for funding programs. We want to get that program funded by all the resources that are potentially available to that person. Strive for excellence in individual experience and outcomes. We want good things for our folks, positive experiences to happen in people's lives. And so we want to really look at how we can make things, and clients excited and happy and looking forward to each day. Um, Foster transparency on service delivery and performance. Be open. We want to make sure that our records, that how we do things are out there, that for people, if a licensing evaluator, regional center, others come out to our facilities, it's the record's there. We keep it available, and it really explains what's going on with that individual. We're not trying to hide things. Okay, wait a minute. It's not about we're going to get caught and they're going to play got ya. It's about we share the information that we have with each other. And finally, the promote and provide innovative technology solutions. So if you have clients in your home or in your day program who need adaptive equipment, um, or voice communication, hearing issues, other things that would be helpful. And these days, when I first started out, a little miniature soundboard for maybe someone with cerebral palsy who had limited speech would cost thousands and thousands of dollars. Now the cost of this stuff is very reasonable to provide for adaptive equipment. And in many cases, it can be covered by Medi-Cal, or regional center has a speech and language specialist, and some other agencies that are out there that can assist. So if somebody needs adaptive equipment to make them more functional. I just read something the other day that was talking about elderly, and they said that for older adults who have hearing problems and who are not getting adaptive equipment, or not getting hearing aids, there's a higher rate of Alzheimer's. And they attribute that possibly to the fact that the person has less understanding of what's going on in their environment. And so that they're not as sharp, and they're losing skills over time. So we want, as whenever possible, make sure that we are challenging people and providing them with the equipment that's necessary. Okay, and with that, I'm pretty much done for the day. If anybody would like to open their mic and ask questions, or would like additional information, we've got about up to 13 minutes if people would like.
Jeff, I think you covered just about it all, man. I appreciate it. Wealth of
Okay,
knowledge.
all right. So Dante, you now know everything there is to know about Title 17 and 22.
Not everything, but I do have some knowledge base. So,
Okay. So again, if you ever need to find any of this stuff, go to the DDS website, and right there you'll see one of the tabs you can click on is rules and regulations. And when you click on that, you can then go right to either the Lanterman Act, and there's two versions of the Lanterman Act that are on the DDS website. One version is the actual law, which is like 300 and some odd pages, and then there's the second version, which is a consumer-friendly version, which is a condensed version that's specifically meant for the people, the persons that we serve. And so if you want to share the Lanterman Act with your consumers at your facility, good document to use. It was developed about 8 or 10 years ago, and it's still pretty relevant. And I would encourage you to share that with the individuals that you serve. Other questions or concerns that people have? Okay. Again, this will be made available on our website probably within. I get it to my administrative assistant probably later today. When she works with our web tech people, and sometimes it gets on there right away. Sometimes it takes a week or two, but it will be up there. And also the slides will be up there too. And if you just go to bakersfieldarc.org, and if you look up towards the top, it says HCBS Boot Camp. That was sort of the throwback to what we were doing last year, but we just sort of shoehorned everything in there. All the trainings that we've recorded, which are most of the trainings, are all at that location. And just one last thing that we are looking at next month. Our community of practice will be on cultural competency, which is an area that we all can benefit from. And we'll look forward to seeing you again. The second Tuesday of the month will be day or the second Wednesday, excuse me, of the month will be day and residential. I mean, day and vocational. Third Wednesday will be residential, and the fourth will be for these webinars. So, and that'll be pretty much the standard for the next few months. We are looking at also adding in. We're developing our final memorandum of agreement and understanding with the Council on Quality Life, CQL. And CQL is a national organization that has a number of courses, and they will be providing those free of charge. They normally charge for those, but we will be offering up to 40 people. There'll be webinars. There'll be half-day webinars. There'll be at least one of those a month, every month on specific topics. In addition to that, we're going to be having, they have a 5-day intensive training on a tool they call the POM, POM, and that will be available. We're looking at probably after the first of next calendar year for that, and there'll be 12 slots available. Two of the Bakersfield ARC staff are going to be taking that training in December, and we'll get the background on it and an understanding of it, so that we can then take it out to the community. But if you or one of your senior staff people would like to be trained in it, it's a 5-day training. It normally costs $800, free under this grant. So keep posted. We'll keep the newsletter that we've been sending out, which had been monthly under this year's grant, is going to be sent out it had been twice a month. It's now going to be sent out monthly, and that will probably be in the second week of the month. So second week in November, you'll probably be receiving the newsletter. If you're not on the newsletter, you can just contact Irene. We gave her address earlier at Bakersfield ARC, and she can put you on the mailing list so that we will email you a copy of the newsletter. Any other questions or concerns? Okay, well, I thank you for your time today. Hope this was informative and helpful, and we'll see you next month. Bye-bye now.
Thank you, Jeff. That was great.